Welcome to INAN's Student. INAN Student is a platform for law students to come here and deliver a lecture on the topic of their choice. Today we have with us law student Mahek.Shaikh. She is going to speak on judicial activism. She is from KES Shri Jayantilal H. Patel College of Law. So without wasting further time, I would request Mahek to commence with her lecture. Thank you.
Good morning everyone. Today I am Mahek.Shaikh, a law student from KES Shri H. Patel Law College, stand before you to discuss the concept that has shaped the course of justice in modern democracy, that is judicial activism. The doctrine refers to the proactive role of the judiciary in upholding constitutional rights, ensuring justice, and sometimes even stepping into the domain of legislature and executive when necessary. It is rightfully said by Justice V.R. Krishna Iyer, one of the founders of judicial activism, that every judge is an activist either in the forward gear or in the reverse. In a democratic setup, the judiciary is expected to interpret laws, but in certain situations, judiciary go beyond interpretation and plays an active role in policy making and governance. Judicial activism was first coined by Arthur Schlesinger Jr. in 1947. Judicial activism was originated from USA. In India, the foundation of judicial activism was laid by Justice V.R. Krishna Iyer, Justice P.N. Bhagwati, Justice O. Chinnappa Reddy, and Justice D.A. Desai. They embraced an expansive and dynamic approach to constitutional interpretation. Their decisions played a significant role in transforming the role of judiciary from being a passive interpreter of law to an active participant in shaping public policy and promoting social justice. Justice P.N. Bhagwati, during his tenure as Chief Justice of India, played a pivotal role in shaping public interest litigation. He was instrumental in allowing PILs, thus making the judiciary more accessible to the public and ensuring that court could address societal issues like poverty, human rights abuses, environmental protection. He recognized that the traditional system, where only individuals directly affected could approach the court, was inadequate for addressing issues faced by marginalized sections of society. For example, Raman K. Verma vs. Union of India 1983. Justice Bhagwati emphasized that court could address the issues of social justice and public welfare even without aggrieved party approaching it. This was a landmark shift from earlier notion that only those with direct personal interests could seek judicial redress. Justice V.R. Krishna Iyer is known for his progressive and extensive stance in the judiciary. He believed that judiciary should play an active role in ensuring social justice and protection of human rights. Justice Iyer pushed for the reinterpretation of legal provisions to align them with the ideals of social justice and equality. He recognized that law must be dynamic to meeting the changing needs of society, and judiciary should step in where the legislature failed to protect fundamental rights. For example, Sunil Bhatra vs. Delhi Administration 1978. In this case, Justice Krishna Iyer expanded the scope of judicial intervention in prison reform and prisoners' rights, which was considered an area outside the direct purview of judiciary at that time. These justices not only redefined the role of judiciary but also ensured that constitution remained a living document that could adapt the evolving needs of society and plays a crucial role in laying the foundation of judicial activism. Judicial activism signifies the role of judiciary in protecting the rights of citizens. In India, the Supreme Court and High Court are vested with power to examine the constitutionality of any law, and if such law is found to be unconstitutional, with reference to the provisions of the Constitution, the court can declare the law as unconstitutional. Article 142 of Indian Constitution gives the court the discretion to issue orders of justice in any pending matters. Article 226 of Indian Constitution gives High Court the power to issue orders to enforce basic rights and other legal rights. In simple terms, judicial activism empowers the judiciary to correct injustices when the executive and legislative branches fail to act. It is often exercised through PIL and progressive interpretation that addresses societal issues like poverty, human rights, environmental protection, and corruption. I would like to discuss a landmark case in India in which judicial activism played a crucial role, that is Keswananda Bharati versus State of Kerala, 1973. It was a defining moment for judicial activism where the judiciary actively protected democracy and fundamental rights from potential misuse by legislature. First, let us know the background of the case. Swami Keshwananda Bharati, the head of the Edanir Mutt in Kerala, challenged the Kerala Land Reform Acts 1969, which sought to impose restrictions on the property rights of religious institutions. He filed a petition under Article 32 of the Constitution, arguing that his fundamental right under Article 14 equality, Article 19 right to property, Article 25 freedom of religion were violated. While the case started as a property rights dispute, it eventually became a debate on the power of Parliament to amend Constitution. The case is a landmark in judicial activism because the Supreme Court asserted its authority over Parliament and created a constitution safeguard against excessive amendments. A 13-judge bench, the largest in the Indian history, deliberated this case. The Supreme Court ruled that while Parliament has the power to amend the Constitution under Article 368, it cannot alter the basic structure of the Constitution. Basic structure doctrine was introduced. The doctrine was a direct example of judicial activism as the court created a new constitutional principle not explicitly mentioned in the text of the Constitution. This was a bold move by the judiciary to safeguard the Constitution against authoritarian tendency, making it a prime example of judicial activism where Supreme Court acted as a guardian of Constitution and also reinforcing the role as a protector of fundamental rights. The Supreme Court took a proactive role in defending constitutional integrity and democratic values. The judgment had a profound impact on Indian democracy, shaping the way judiciary exercised its activist role. In Indira Gandhi versus Raj Narayan case 1975, the Supreme Court used the basic structure doctrine to strike down the 39th Amendment, which sought to keep the election of Prime Minister beyond judicial review. Minerva Mills versus Union of India, another example. 1980, the court struck down parts of 42nd Amendment, reaffirming that judicial review and fundamental rights are a part of basic structure. The basic structure doctrine empowered the judiciary to intervene in the legislative actions when necessary. The case strengthened the judicial review and laid the foundation of future judicial activism in India. I would like to discuss another landmark case where judicial activism plays a crucial role, that is Vishaka versus State of Rajasthan 1997. In this case, the Supreme Court stepped in to fill the legislative gap by laying down guidelines for the prevention of sexual harassment at the workplace, known as the Vishaka Guidelines. This case is a powerful illustration of how the judiciary can take an active role in lawmaking when legislature fails to act on critical issues. Let's look at the background of this case. The case was filed after the brutal gang rape of Banwari Devi, a social worker in Rajasthan, who was assaulted while attempting to stop child marriages in Rajasthan. In the absence of specific legislation on workplace sexual harassment, a group of NGOs led by Vishaka filed a petition under Article 32 before the Supreme Court demanding legal protection for women. This case is a textbook example of judicial activism. Since India had no specific law on workplace sexual harassment, the Supreme Court used judicial activism to frame legally binding guidelines until the Parliament enacted laws. These guidelines were modeled on the international treaty which India had ratified. This demonstrated judicial creativity and activism by incorporating international law. In the jurisprudence, the court acted in full legislative capacity, which some critics argued about, that is judicial overreach. The Vishaka Guidelines remained in effect until 2013, when Parliament finally passed Sexual Harassment of Women at Workplace Act. Now look at some pros of judicial activism. Judicial activism has several advantages, out of which some are protection of fundamental rights. When the legislative and executive branches fail to safeguard the rights of individuals, the judiciary steps to ensure that justice prevails. This is particularly true in cases where marginalized communities face systematic oppressions. Promotion of social justice. Activist court often addresses issues related to social justice, ensuring that all citizens, irrespective of their background, have access to justice. Cases like Bandhua Mukti Morcha vs. Union of India 1984, which tackled bonded labor, are a testament to this. Filling gaps in legislation. Sometimes laws are outdated or vague. The judiciary, through creative interpretation, can help bridge the gap between the law and evolving societal needs. In this way, courts act as an essential force for law reform. Now let's look at the cons of judicial activism. Judicial activism is not without its criticisms. Judicial overreach. Critics often argue that judicial activism often leads to judicial overreach, where courts step into the realm of the executive and the legislature to undermine the principle of separation of powers. It has been argued that court may not be best equipped to make decisions that involve political or policy considerations. Lack of accountability. Judges are not elected representative and thus are not directly accountable to the people. This raises concerns about the legitimacy of the judicial activism, as unelected judges may shape the policies that affect millions of people. Undermining democratic institutions. There is also a concern that judicial activism might be inadvertently undermine the role of legislature, which is elected to make laws based on the will of people. If judges start making laws or influencing policy decisions, it could destabilize the democratic process. There is a fine line between activism and overreach. The key challenge with judicial activism lies in balancing activism with restraint. Court must be vigilant not to cross the line between interpreting laws and creating it. While activist courts have undoubtedly played a significant role in protecting the rights and pushing for reform, they must be mindful of their constitutional mandate and not infringe upon the democratic functions of other branches of government. Judicial activism in contemporary India. In recent years, India has witnessed numerous cases where judicial activism has been at the forefront. One prominent example is Supreme Court's National Judicial Appointments Commission case 2015, which protected the independence of judiciary. Another is the Sabarimala case 2018, where Supreme Court struck down the ban on women of menstruating age to enter the Sabarimala temple, showcasing how judiciary can influence social norms. However, judicial activism also continues to face challenges, especially in cases where it may seem that the judiciary is overstepping its bounds. The debate around the judicial appointments, the handling of controversial matters like Article 370, revocation, and the ongoing judicial independence discourse illustrate that judicial activism is still a hotly contested issue in India today. In conclusion, judicial activism strengthens the democracy by making a judiciary a guardian of fundamental rights and social welfare. Judicial activism is a powerful tool to uphold justice and prevent misuse of legislation. Though it is also important to recognize the need for balance between judicial intervention and respect for the democratic principles that guide our constitution. As a future lawyers, it is essential for us to understand the nuances of judicial activism, ensuring that we continue to advocate for justice while maintaining the integrity of the democratic institution. Thank you.
Mahek, thank you very much. It was really nice to hear from you because you had covered a long span, I think starting from Keshwananda Bharati and concluding up to the current Sabarimala cases and even the other important cases which are still going on in Honorable Supreme Court of India. So it was a nice overview to hear from you. Thank you very much. A small token from Hammurabi to you. This is for you.